Today we're going to talk about exempt assets and summary distribution. My name is Gregory Singleton. I'm an estate planning and probate attorney who lives in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just a reminder, if you like today's video, please feel free to hit that like and subscribe button. It really helps support the channel. And a couple caveats before we get going. First of all, this video is for educational purposes only. It is not legal advice. And secondly, we're going to be mainly talking about Minnesota law. So if you live in another jurisdiction, you'll want to talk to an attorney in that jurisdiction with your specific questions. So what do I mean by exempt assets? Well, an exempt asset is one from which creditors cannot make a claim to. So if the decedent had debts on at the time of their death, a creditor cannot come back and say, I want you to pay those debts with those certain assets. And you can't do that because they're exempt. Now, they're a little bit different than probate assets. We've had another video talking about what is a probate asset and what is not a probate asset. Exempt assets are slightly different. It's a subset of your probate assets. And there's three types, essentially. There's the homestead, there is selected property, and there is family allowance. So let's jump right into it and talk about what a homestead is. Now, a homestead is a property at which the owner lives, and all owners live. Now, it's going to be a little bit different state to state and even county to county, what is required and what you have to do to get a property homesteaded. For example, in Hennepin County, where I live, you have to have the homestead to be established by December 15th of the year in which you bought the house. All owners must permanently occupy the house, and there are some limitations to it. First of all, the acreage limitation in Minnesota is going to be 160 acres. So if you have more than that, you cannot homestead the extra acreage. Second of all, the value of the property cannot exceed $450,000. Unless it's an agricultural property. Of course, if it's an agricultural property, I believe the value is $1,125,000 if the property is used for agricultural purposes. Now, these are the values for 2020. The values change every other year. So in 2022, which we're getting real close to, we'll see some new numbers probably going up. The homestead, for it to be exempt, must pass to either the spouse or the decedent's children. Now, it doesn't matter whether the children are adults or minors. They can be either, it's irrelevant. It's also irrelevant as to whether the spouse or the minors or the children live in the house or not. Now, there is one exception here to the exempt asset status, is medical assistance. If there are medical assistance costs that the state wants to claw back, they can claw that back from the value of the property. The second type of exempt assets are selected, or select property is what I call them. And it's going to include household goods, which is going to be furniture and appliances, up to $15,000, personal effects up to $15,000, and one automobile, regardless of the value. Meaning you could have a collector car out there worth $100,000 and it can still be exempted under the select property. Now, the property must pass to either the surviving spouse or to the decedent's children. Again, it's fine if they're adults. However, if the decedent purposefully omitted one of the children in their will, then that child cannot receive the selected property. Again, we have a medical assistance exemption, but it's limited to the adult children. If there are adult children and medical assistance claims, medical assistance is going to have priority over the adult children receiving the selected property. The final type of exempt property is the family allowance, and this is a little bit different than the other types of property. Previously, we're narrowing in on a certain type of property. Family allowance is an allowance for a purpose, and it is money that is given to the spouse and minor children that were supported by the decedent or should have been supported by the decedent, and the decedent had an obligation to support. It's money for them to live on, and the amount of this money is $2,300 per month. How long it goes depends on the estate. If the estate is insolvent, meaning it can't pay all its debts, then the family allowance can last for up to only 12 months. But if the estate is solvent and it can cover its debts, then the family allowance can last up to 18 months. Importantly, the family allowance does not need to wait until probate is over. It actually can start before even the creditor's claim period. So all those trust attorneys out there that say you have to have a revocable living trust because otherwise all the assets are going to be frozen and your spouse and your children will have nothing to live off of, they're blowing smoke. The reality is there is an allowance of for them to live off of and to take care of them during the probate process. So exempt assets matter because the creditors cannot access those assets to pay off debts. What about a situation where the entire estate is exempt? Say there's only a house left and very few personal effects and no money in the bank. What do we do in that case? Do we need to go through probate if the creditors are going to get absolutely nothing? Well, the answer is no. We have what's called in Minnesota a summary administration and distribution. It's a statutory acknowledgement of the need when there is very few or no assets to pay to creditors. And I say very few because there must be less than $150,000 of assets to pay creditors. And you get to this number by taking the entire assets, you remove the exempt assets, and the remainder must be under $150,000. If there's debts, then you pay it out of the $150,000 and you go your merry old way. The procedure is much easier than a full probate. Basically, you get a hearing set, you give published notice and direct notice to any creditors or interested parties. You have the hearing that adjudicates the errors and establishes the testacy, and then you pay the debts and you're done. That's it. It's a great little procedure that you can use if you can. I highly recommend it. So that is my take on a basic summary of exempt assets and summary procedure. I hope you liked today's video. If you did, please feel free to hit that like and subscribe button. It really helps support the channel. Also, if you liked what we're talking about today, we're in the middle of a series on probate. We're getting close to the end of it. I got about 2 more videos after this one. But we do a new video every other Wednesday. After the probate series is over, we'll go back into general estate planning. If you have any questions, leave them in the comments below or just send me an email. Otherwise, until next time, this is Gregory Singleton with Signature Law.